My name is Jennifer Perkins, and I am the president of the Phoenix Lawyers chapter of the Federalist Society. So since they've given me the microphone, I'm going to take a moment to use that prerogative and encourage any of you that are not currently involved in a lawyers chapter or student chapter or regularly attending the events. I think we've demonstrated here today that it's worth your time to check it out. We've got a number of folks involved in chapter leadership here. Lisa Ezel, who's the director of the Lawyers Division, is here, and a lot of other staff. So really, I encourage you to think about getting involved. It's my honor to introduce the Honorable Milan D. Smith, Jr. of the United States Court of Appeals for the Ninth Circuit. He'll be moderating our first panel this afternoon. Judge Smith graduated with honors from Brigham Young University in 1966, and in 1969 he received his Doctor of Law degree from the University of Chicago Law School, which he attended on a full tuition scholarship. Judge Smith was nominated to the Ninth Circuit by President George W. Bush in February 2006 and was unanimously confirmed by the United States Senate 3 months later. Prior to his appointment to the Ninth Circuit, Judge Smith had a distinguished career as a practicing attorney in the public and private sectors. He was an associate at the Los Angeles law firm of O'Melveny and Myers from 1969 to 72. He was the founding and managing partner of the boutique law firm of Smith and Hilbig, later Smith, Crane, Robinson, and Parker, which he co-founded in 1972. And he was the president and general counsel of the Los Angeles State Building Authority from 1983 to 2006 and vice chairman of the California Fair Employment and Housing Commission from 1987 to 1991. That's not our topic, but I think I might need to talk with you about that later a little bit. Judge Smith has extensive practical experience in the areas of environmental, corporate, and tax law. He is one of the Ninth Circuit's most prolific writers and has authored hundreds of opinions for the court. He serves on several court committees, including the Judicial Conference of the United States Committee on Financial Disclosure and the Ninth Circuit Court Executive Committee. After today, he will be adding to his resume the moderation of this fantastic panel, which we are all very excited about. So, Judge Smith.
Thank you. Good afternoon. It's an honor to be here and to be with my distinguished colleagues on the panel. I want to start out by making a very few brief remarks to respond to my friend Pete Wilson's comments about the Ninth Circuit. In all seriously, Pete is a friend, have great admiration for him, but I want to cheer you up a little bit. I want to be the guy in the horse manure stable and let you know that there is in fact a pony there. I was appointed by George W. Bush. I come from some fairly conservative stock. One of my cousins is Mike Lee, if that gives you any idea. Rex Lee was my cousin. So I come from a background that understands conservative thought. And I want you to know that unlike the executive and legislative branches of our national government, the court system, and particularly, I know, the Ninth Circuit, functions remarkably well. Unlike some people in certain settings that scream at each other, believe it is treason to exchange ideas, we actually talk to each other. We communicate with learned, basically memos back and forth, debating what the law is or should be. You'll be pleased to know that about 93% of our opinions are unanimous, non-published opinions. And we have anywhere from 12,500 to 16,000 cases filed before our court every year. So most of it, everybody agrees. There's nothing political, nothing controversial about it. Most of the written opinion, which are the roughly 6.5% after that, are also unanimous, usually having nothing whatsoever to do with anything that you would find the least bit controversial. Yes, the Supreme Court does reverse us, but after Steve Reinhart retires, that will be cut roughly in half. Now, Steve is a good friend, and he's very, very dedicated, but in our EDPA cases, in a particular area, 14 cases have been, 14 reversals in the last 4 years, 10 of which have been unanimous. About 2/3 of those were Steve's cases. So the reality is the Ninth Circuit as a percentage of our cases, is not the most reversed. The Sixth, the Fifth, and certainly the Federal Circuit, as a percentage of cases, are reversed more than we are, and it's going down. So I want you to know there is a pony there. There is a pony there. And I am proud to sit on the Ninth Circuit Court of Appeals. It does, again, I don't agree with all of them. I've read a number of dissents. But these are fine people. I want you to know I am very proud of my colleagues. They really, really work hard, and they really, really believe that they are doing what they are asked to do under the Constitution of the United States. So having said that, I'm going to go to our topic, but I couldn't let my friend Pete say what he said without some response. I'm a lawyer after all. I mean, come on. You got Anyway, today we were going to have the Attorney General of the state of Arizona begin. He is unable to be with us today, and since General Brnovich is not available, I want to briefly introduce the panel members and the topic. The theme of our panel discussion today is federalism, the environment, land use, and energy independence. The relationship between the federal government, the states, and the citizens regarding land, the environment, and the extraction industries has often been uneasy and tense, especially in the West. Unfortunately, this week we saw some of that tension spill over into violence. The federal government's physical control of land has evolved over time, starting when the original states ceded land west of the Appalachian Mountains that they had previously claimed, and continuing with the federal government's acquisition of land through the Louisiana Purchase, the Oregon Compromise, and the Mexican War. Initially, Congress's policy was to transfer this land to private ownership in order to encourage settlement and development. But by the late 1800s, a conservation movement came into being primarily under the Antiquities Act that sought to preserve some of the federal lands for perpetual public use. Throughout this almost two-century period, many thought and strongly desired that much of the remaining federal land would be transferred to the states where it was located. But in 1976, Congress enacted the Federal Land Policy and Management Act, which declared as a matter of federal law that the federal government would retain ownership of the lands that it then possessed. As a result, approximately 640 million acres of land remains in federal hands today, including approximately 85% of Nevada, 65% of Utah, 61% of Alaska, 53% of Oregon, 48% of Wyoming, and 46% of California. Federal ownership of vast tracts of land within a state obviously complicate a simple understanding of the federal relationship between the state and the federal government. Beyond direct ownership of land, federal environmental legislation and regulation have had some important implications for federalism. Some environmental legislation is expressly predicated on a Federalist model, a good example being the Clean Air Act. Although air pollution travels freely across state lines, the Clean Air Act expressly allows them flexibility in developing plans to meet air quality standards. However, this express state-federal partnership contemplated in the Act has not prevented state-federal lawsuits concerning the implementation and interpretation of the Act, as states are often dissatisfied with the Environmental Protection Agency's implementation of the Act. Most of that litigation accuses the EPA of overreach and overregulation, although occasionally states seek more regulation, as occurred in the 2007 Supreme Court case of Massachusetts versus EPA. Not all environmental regulation provides flexibility to the states, and a number of states have concluded that the recent environmental regulations overstep the federal government's legitimate role and are litigating accordingly. Not all of the challenges involve federalism per se, since they often involve issues of science and administrative law. However, the fact that the states are leading the way in some of these challenges appear to reflect a newly assertive Federalist model and a dread of further federal involvement or interference into what are perceived as historically local matters. Many of these cases are pending, and as a sitting federal judge, I won't comment on their merits. However, I will mention 3 cases in which a number of state attorneys general have taken the lead role in challenging EPA rulemaking, largely under the banner of federalism. These cases involve the Waters of the United States Doctrine, the EPA's Clean Power Plan, and the EPA's new ozone standards. First, the Waters in the United States case. In August of 2015, North Dakota and 12 other states obtained an order from the United States District Court for the District of North Dakota enjoining a rule promulgated by the EPA and the Army Corps of Engineers under the Clean Water Act. The agencies had attempted to draft a rule in compliance with the Supreme Court's 2006 decision in Rapanos versus United States. Rapanos was a plurality decision by the Supreme Court with a concurrence by Justice Kennedy. That concurrence has generally been understood by many to be controlling as the narrowest ground of decision supporting the judgment pursuant to Marks versus United States. The district court focused on the Kennedy concurrence since it was the agency's focus. Kennedy wrote that for waters to fall under the Clean Water Act jurisdiction, they must, in quotes, significantly affect the chemical, physical, and biological integrity of other covered waters more readily understood as navigable. He criticized the rule at issue in Rapanos as leaving, in quotes, wide room for regulation of drains, ditches, and streams remote from any navigable, in fact, waters. You can see the extremely wide range possibility. Here the regulation allowed for jurisdiction over, in quotes, any area that has a trace amount of water so long as the physical indicators of a bed and banks and an ordinary high water mark exist, but excluding drains or ditches. So you're talking about potentially somebody that has a little pond in their back a farm that has no connecting water, and it might still be covered by federal regulation under the proposed rule. The district court found that the states were likely to succeed in their challenge and granted a preliminary injunction preventing the rule from taking effect. The case is ongoing, but has enormous potential for federal regulation of what has previously been considered a strictly state law matter. Relatedly, Senators Inhofe and Sass have asked the DOJ to investigate whether the EPA violated the law by asking supporters to share messages supporting the EPA's regulation on social media without attributing it to the government, and linking to environmental group websites that ask readers to contact lawmakers on the topic. Secondly, the EPA's Clean Power Plan. On October 23, 2015, the EPA published in the Federal Register a final rule entitled Carbon Pollution Emissions Guideline for Existing Stationary Sources, Electrical Utility Generating Units, referred to more concisely as the Clean Power Plan. It is 304 pages of small 3-column text with 1,072 footnotes. The day the EPA published the rule, 23 states, led by West Virginia, filed a petition for review challenging the rule in the D.C. Circuit. The states asked the D.C. Circuit to stay the rule from going into effect during the challenge, but the circuit denied the request. Undeterred, the states have now asked the Supreme Court to stay the implementation of the regulations. Interestingly, the National League of Cities, the Conference of Mayors, and a number of individual cities have filed amicus briefs in support of the EPA. Third and final challenge I'll mention before we turn to the panel is the proposed revision to the National Ambient Air Quality Standards for ozone. Those standards were published as a final rule on October 26, 2015. That same day, Murray Energy, the nation's largest coal producer, filed a petition in the D.C. Circuit seeking to invalidate them. 5 states, led by Arizona, filed a companion petition seeking invalidation the next day, and Texas filed its own petition 2 months later. All 3 of these proposed rules represent a potentially massive new federal involvement in previously unregulated or far less regulated areas of law. Moreover, each was promulgated by the current administration with a publicly stated objective of bypassing an uncooperative Congress that did not share some of the administration's environmental goals. Some claim that because of these and other newly promulgated regulations in other areas of law, federalism, as envisioned by the founders, is in jeopardy. I look forward to hearing the panel's views concerning these and other challenges to federalism. We're very fortunate today to have a distinguished panel of scholars to address the issue of federalism, the environment, land use, and energy independence. I will first introduce them and then invite each to come to the podium, seriatim, to speak for approximately 10 minutes, addressing one or more subjects of our topic today. When each panel member has addressed us, I will then invite panel members to pose questions to one another and I to them to further contribute to our understanding of the issues raised. We hope to reserve a few minutes for questions for the audience at the end and to end on time. With that background in mind, I'm pleased to introduce our panelists in the order of their presentations. I think you'll see a more detailed biography of each member in some material that I think you have. First, Tony François. Tony is a senior staff attorney at the Pacific Legal Foundation. Next is Professor Rick Frank, who is director of the California Environmental Law and Policy Center at the University of California at Davis School of Law. Next, Professor Donald Koshin, Associate Dean for Research and Faculty Development at the Dale E. Fowler School of Law, Chapman University. And finally, Professor Justin Pideaux of the Sturm College of Law, University of Denver. So I look forward to hearing from these gentlemen. We'll start with Tony.
Thank you very much, Your Honor, and I'd like to echo the thanks that all the speakers so far have extended to the Federalist Society and all of the staff that organized this conference today, and for everybody for attending. I'm going to try to take it within 10 minutes' time, a quick walk through several federalism issues that are currently pending in litigation at various stages that highlight the tension between federal government and state government control and how both of those affect private property resources. I won't spend much detail on any of these, but perhaps we can answer questions on them if time permits. So I'm going to start with water resources. Judge Smith talked about the Waters of the United States rule. The only thing I would add to that is kind of a shorthand that I think expresses the reach of the Waters of the United States rule. For an awful lot of the area that is newly covered by the Clean Water Act under the new rule, the effect of the rule is to identify various areas of what is most of the time, sometimes all of the time, dry land, much of it privately owned, and recharacterize that dry land, privately owned dry land, as the federal government's water, which you then need the government's permission through the Corps of Engineers to use. And you can see, for example, if you go to the American Farm Bureau's website dedicated to the WOTUS rule, they've done some GIS analysis of various states where they apply the conditions of the new rule to the landscape of those states. The one for California shows that up to 95% of the area of the state of California is covered by the new Waters of the United States rule. A couple of other areas, but what I would say, though, about the Waters of the United States and the Clean Water Act generally is that this is an area in which the Supreme Court has recently been fairly active, given the pace of issues moving through the federal courts. Fairly active. They've issued two important rulings in the last decade. They are looking at one case right now, potentially others that deal with court supervision of the EPA and the Corps of Engineers under the Clean Water Act. And so the scope of waters of the U.S. is actually relatively, I wouldn't say well supervised all in all by the federal courts, but that is an issue that the courts are aware of and deal with a lot. I want to highlight a couple of things that I would describe as sort of recent entries into areas of concern for federalism. The common point is what's called the clear statement rule. And if you look at the Supreme Court's decisions in the Solid Waste Agency of Northern Cook County, the Swank case, which invalidated the migratory bird rule under the Clean Water Act, as well as Rapanos that Judge Smith discussed, they both say that Congress has established a very, very long practice of deferring to state control of water resources, and that absent what's called a clear statement of congressional intention to the contrary, the courts will infer that congressional deference to state control in congressional acts. And they find this from statutes going all the way back to the Mining Act and the Homestead Acts in the mid-19th century, the Reclamation Act at the turn of the century, the Forest Service Organic Act, and various other federal land laws, which all specifically defer to state water law and local control of water resources. There are two areas, and I feel like I'm between a rock and a hard place, because Governor Wilson is talking about the Ninth Circuit, and Judge Smith is on the Ninth Circuit. So I have to talk about a couple of recent Ninth Circuit decisions, which muddy the waters in this area somewhat. There is a recent series of decisions dealing with the Federal Reserve water rights doctrine out of the state of Alaska, in which the Supreme Court has established a very narrow rule, which says that when the federal government withdraws otherwise public land to establish federal facilities, whether it's a national forest or a military reservation or an Indian reservation, that necessary water rights are also reserved for that purpose. The Supreme Court has always construed that very narrowly. The Ninth Circuit recently has applied it much more broadly and basically said, even affording a type of Chevron deference, if the federal agency kind of thinks it could use water rights, in the Alaska cases in particular in connection with national parks, then we're going to defer to their judgment that they need water rights rather than the Supreme Court's analysis of this doctrine, which is to look very specifically at the statutes and then construe them narrowly. The most recent case addressing this was Alaska versus the United States, which was decided a couple of years ago. The Supreme Court denied cert in that case. In addition, there's a recent decision out of the Ninth Circuit dealing with the ever complicated division of water among various parties in the Central Valley. And in that case, the Ninth Circuit, rather than deferring to state water law decisions on how to apportion water under various federal contracts, instead deferred to an arguably contrary interpretation of state law adopted by the Bureau of Reclamation in interpretation of state law. And so here you've got a pivot from this very uniform deference to state law in resolution of water resource controversies to deference to the federal agency's interpretation of state law. Cert was denied in that case, but I think in both those cases, these flag issues that are going to be a federalism problem going forward. The other topic that I want to talk about in the federalism arena has to do with forest fires and fire risk in federal lands. In the materials that I think are on the thumb drives everybody has, there's a paper based on an amicus brief that we filed in a pending case in the 10th Circuit, but it deals with the question of whether or not federal agencies that manage lands that are then destroyed by fire and cause harm to neighboring properties can be held liable under the federal common law of public nuisance theory. The brief was filed in a kind of an interesting case because it arises out of the state of New Mexico. Under a state law, a New Mexico county, Otero County, had adopted a local ordinance finding that the local national forest, the Lincoln National Forest, was being maintained in a condition of public nuisance due to fire risk. And then the county ordinance authorizes the county, without the consent of the Forest Service, to go on the national forest and use logging and other means to reduce the fuel load in the national forest. So needless to say, the Forest Service is not impressed with this. And so this case is actually brought by the United States to declare the county ordinance invalid under the Supremacy Clause. The county has argued, unsuccessfully so far, the trial court, and so now this is in the 10th Circuit, that under the 10th Amendment, the power reserved to the state to abate nuisances allows the county to abate nuisances even if they occur on federal property. And I think that the trial court's decision that cannot overcome the Supremacy Clause and the federal property clause in the federal Constitution is probably not an unsurprising result. What we've argued alongside that is that it's important, as the court looks at this, to be careful of concluding that the agency, as a matter of law, cannot be maintaining a public nuisance on property it owns, managed under statutes that authorize the management of the property. And it relies heavily on a recent case from the 7th Circuit called Michigan versus Corps of Engineers, which holds that under the federal common law of public nuisance doctrine, states may state claims against federal agencies for maintaining a public nuisance, and the federal courts may order federal agencies to abate those nuisances. So this is, I think, one approach to possibly resolving some of the adverse impacts that federal management of federal property within the western states is having on states, local communities, private property owners who have to live with the condition that the national forests have gotten into, which is overgrown, unused, and posing enormous risks of catastrophic fire. The final item that I'll highlight, and then if there's time during the questions we might discuss it a little bit, has to do, instead of with horizontal federalism, with vertical federalism, with horizontal federalism and the inverse commerce clause. And I would briefly take issue with one of the comments made earlier during the morning panel on what Congress and the founders were thinking of in establishing the Commerce Clause and the condition of commerce at the founding. It's precisely to prevent states like New York from using their superior market power as a port of entry to wage economic warfare against neighboring states, that the Commerce Clause was established to prevent things like state-to-state import tariffs and things that would prevent the formation of the national market that we now have. That's my 10. The low carbon fuel standard case arises out of California. It was initially decided favorably to the plaintiffs and then reversed on appeal in the 9th Circuit, is now pending back in the trial court. But essentially what it deals with is a state regulation that regulates the sale of ethanol and other fuels sold in California. But what it actually regulates is how they are manufactured, regardless of where they are made. And so it regulates how ethanol is made in Nebraska and Iowa and all the other states where ethanol is a significant product. It does not regulate any aspect of the fuel itself when it comes into California. And so there's no principal distinction between the low carbon fuel standard regulation and, for example, a regulation that would say you may only sell cars in California if they were built by union labor where they were made. That's the nature of the regulation. There have been several similar laws that the state has passed and have been subject to inverse commerce clause challenge in recent years. Things like the sale of foie gras. There is a state law on compensation of artists for artworks and ensuring that a certain percentage is provided. Regardless of where they were actually created, a lot of these cases have been unsuccessful at the trial court level, and yet the pattern that is emerging is one state, because of its market power, California is roughly 12% of the national market for many products, because of its market power can regulate how commerce is engaged in other states. And so I think this is also an important conflict between federalism and, as Christina Sanders put it, state power in the environmental context. So I'll conclude with that and then hand off to the next speaker.
Good afternoon. I'm Rick Frank. I'm a law professor at UC Davis, and I'm actually here wearing two hats and speaking in two capacities. One is someone who's taught environmental law for about 4 decades, but I've only done so on a full-time basis for about the last 10 years. Before that, I spent 30 years working in the California Attorney General's office for 6 different attorneys general, 3 Republican and 3 Democrat. And so that view and that perspective also informs some of the comments I'm going to make. I'd first like to thank the Federalist Society for inviting me to speak at this conference and for holding it here at such a beautiful and inspiring setting. This is my first visit to the Reagan Library and Museum, and it is truly stunning. It's, I believe, both necessary and proper that this program on federalism incorporate a discussion of environmental law because environmental law, with the possible exception of social welfare issues, is that issue of federal law that I think is most heavily imbued with federalism principles. And the basic fabric of federal environmental law was set some time ago when I was in law school in the early 1970s, and it was in the decade of the 1970s that the torrent of federal environmental legislation really came to pass that still forms the cornerstone principles of federal environmental law in 2016. And there are 2 aspects of that federal environmental law program passed by, on a bipartisan basis, by the way, by a democratically controlled Congress and signed into law by a Republican President, Richard Nixon. And I often confound my law students when I ask them to name the most influential environmental president in the history of the United States. I say, with the possible exception of Theodore Roosevelt, another Republican, that would be Richard Nixon by virtue of his time and creation of the EPA. There are 2 features of that federal system of environmental law that I think are quite important and reflect the best principles of federalism. One is that most of, not all, but most of those federal statutes include principles of shared delegation of responsibility to implement and enforce those federal environmental laws. The Clean Water Act and the Clean Air Act most prominently feature an opportunity, not a requirement. The federal government does not commandeer the states, but offers the states an opportunity to apply for and receive authority to, delegated authority to administer key programs of the Clean Water Act and Clean Air Act. Standing in stark distinction with that is the Federal Endangered Species Act, which in my view is the most controversial of federal environmental laws today, even though it hasn't been mentioned in this conference. And I just say part of that is that is one of the few federal environmental statutes that doesn't incorporate that principle of delegated authority and shared federal-state responsibility, which may be a key contributor to the political unpopularity of that statute, at least in some sources. The other key component is that as a creation of the federal system of environmental law, that included the creation of regions and regional administrations of both the U.S. Environmental Protection Agency and the U.S. Department of the Interior and its affiliated departments and bureaus, with the principle that that the federal officials charged with those responsibilities ought to have offices around the country where they can engage with state and local government and other stakeholders. Query whether that's been terribly successful experiment in decentralized governance, but there it is. But I think both of those are important, positive, and innovations and features of the federal system of environmental law. In my remaining time, though, I want to talk about 2 themes that I think and hope are at least somewhat related to one another. The first is the principle, or what I characterize as so-called selective or situational federalism. In the context of public law generally and environmental law in particular, the general perception, I think, is that it is conservatives who are the keepers of the Federalist flame, particularly when it comes to conservation initiatives. But I would say that's an oversimplification, and that recent past history, legal and political history, demonstrates that both political parties and presidential administrations of all political stripes are often unfaithful, shall we say, to principles of federalism in the environmental field. A couple of examples that both coming from California, where it really is, in my view, it has been conservative administrations that have been not attuned to federalism principles. One is on the issue, the contentious issue of offshore oil drilling and whether that's appropriate. When I was in the Attorney General's office, we had a series of lawsuits brought against the federal government to challenge and attempt to halt efforts to lease the Outer Continental Shelf for oil drilling based on the opposition of both political parties in the states and a vast majority of the residents of the state of California. And that litigation was hard fought against both the first Bush administration and by the Clinton administration. And from the standpoint of my clients, in my view, fortunately the state of California prevailed in that litigation. Another example from about the same vintage, in 1974, the California legislature passed and California Republican Governor Ronald Reagan signed into law legislation that, among other things, mandated the state of California through a new California Energy Commission to develop and issue what were not only the nation's but the planet's first energy conservation standards, both for buildings and for appliances. That and the Energy Commission fulfilled that responsibility, and it was quickly met with litigation challenges not only by the regulated community, which perhaps were to be expected, but also by the federal government. Initially a Republican administration claiming that California's efforts to regulate in this field were preempted by federal law. Dormant Commerce Clause wasn't as popular a constitutional theory to advance in those days. And again, happily, from my standpoint and that of my clients at the time, we prevailed in fending off that preemption challenge. I will say, because I don't want to be considered Governor Wilson's pessimistic son from his story, that both of those instances, in my view, turned out well in terms of broader federalism principles. With respect to offshore oil drilling, that has been largely eliminated off the state of California. But in other areas of the country where the public view and the local and state view of offshore oil drilling is different, say in Alaska and the Gulf Coast, oil drilling and exploration does continue apace. And I think that reflecting and deference to individual regional desires and political will makes a good deal of sense. And there's a different kind of success story with respect to the energy standards, first promulgated by the Energy Commission in 1976, I believe, and continually evolved. Not only have those standards been upheld, but they have been replicated in many states and countries around the world. And recently, the U.S. Department of Energy, which for many years was litigating to oppose those standards, has effectively federalized many of those standards, and they have been part and parcel of federal law. So this has been an example, a very positive example, in my view, of what Justice Brandeis so many years ago talked about, the states serving as social and political laboratories to test out ideas that, depending on their long-term shelf life, would be embraced or discarded by the body politic as a whole. The second point I want to raise, and here firmly wearing my former hat as a Deputy Attorney General and ultimately a Chief Deputy Attorney General of California, is a view with respect somewhat different from that of Oklahoma Attorney General Pruitt, from whom we heard this morning, and to talk about briefly and despair, frankly, at what I perceive as the increased politicization of state attorneys general over the last quarter century. And again, I've worked for attorneys general of both parties, all very able, dedicated public servants in office for absolutely the right reasons. But until the 1990s, the early 1990s, I think it's fair to say that attorneys general from both parties and from different regions of the country generally worked on a bipartisan or even nonpartisan basis on issues affecting public policy generally in the environment and with respect to other areas. A couple of examples, positive examples again. The first was a case we haven't talked about specifically, but the 10th Amendment has been invoked, and a number of you like me of a certain age will remember fondly the 1992 decision, New York versus United States, which is the first modern decision to really bring federalism principles in the 10th Amendment out of deep freeze. And in that case, a majority of the Supreme Court, led by Sandra Day O'Connor, found that the federal government's, Congress's efforts to commandeer state functions and responsibilities to implement, yes, a federal environmental law, went too far and contravened the 10th Amendment. I mention that case because although New York was the lead plaintiff, I was involved in the preparation of a multi-state amicus brief that drew about 30 different states in support of New York and advancing those 10th Amendment themes. Those states, and I dug that brief out of my files, and the signatories to that brief included Texas, Ohio, South Dakota, Massachusetts, and California. I dare say that the attorneys general of those states would have a hard time agreeing on what day of the week it is in 2016, but in those days they collaborated very well across party lines and in support of New York's successful 10th Amendment-based challenge. A related example of multi-state bipartisan cooperation among attorneys general was the tobacco litigation, led by state attorneys general when the federal government chose not to go forward against the tobacco industry in the 1980s and 90s. Again, very successful litigation in hindsight, similarly bipartisan, with attorneys general, both Republican and Democrat, working collaboratively and well together. It was in the 1990s, however, that things began to change. And I think a key contributor to that was the creation of two organizations, the Democratic Association of Attorneys General, DAGA as it's known by acronym, and the counterpart Republican Association of Attorneys General, RAGA. And as a result of those organizations and their increased prominence, the role and the activities and some of the incoming attorneys general became more and more politicized and partisan. And as a result of that, I think over the last quarter century, we've seen, as I said, an increased politicization and factionalization of state attorneys general. Some recent examples, and a couple of these have been mentioned. The pending litigation in the D.C. Circuit, the challenge to the Obama administration's Clean Power Plan brought by a number of states through their attorneys general. What hasn't been mentioned is that those are mostly red state attorneys general have been bringing the action, and that has prompted an almost equal number of blue state attorneys general who have filed briefs on the other side, joining with the Obama administration. We see the same pattern in the waters of the United States litigation currently pending in the Sixth Circuit, where you have red states and red state AGs bringing the action, blue states and blue state AGs aligning themselves with the federal government. And then following up finally on Tony's comments, we're also seeing some attorneys general mounting, sometimes in conjunction with the regulated industry community, sometimes on their own, Dormant Commerce Clause challenges to California state-based regulation on Dormant Commerce Clause grounds. The first is the Low Carbon Fuel Standard, which again I participated in both in the Attorney General's office and later in an amicus capacity. And as indicated, while that litigation is not over, the Ninth Circuit has fended off and rejected the first Dormant Commerce Clause challenge to that key component of California's strategy to fight greenhouse gas emissions in California per state legislation. A number of animal welfare laws have similarly been challenged by Midwest attorney generals, as has the Dormant Commerce Clause, and so far, in some cases, those are state voter initiative passed measures, and those have been rejected as well. The key point here is that I worry that attorneys general are devolving into predictable red state versus blue state partisanships in litigation and other contexts, and are in danger of becoming just another set of partisan combatants or litigants in these important areas. And I fear that trend has really undermined and continues to undermine the stature and effectiveness of attorneys general, the chief law officers of their respective states, who in my view can be far more effective before the courts, before the public, before Congress, when they work on a bipartisan basis. Thank you.
Good afternoon. I want to thank the Federalist Society for organizing this conference and for the opportunity to present some thoughts here. My plan is to address the comparative effectiveness of a traditional federalism-based model where states are seen as having primary and unique responsibility for land and resources within their borders. To carry a theme and to sum up my thesis, whether I am the pessimistic or the optimistic son depends on who owns the room. Many at this conference may know this one by heart, but it's worth repeating. James Madison famously observed in Federalist 45, foreshadowing what would become the 10th Amendment, that, quote, the powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The powers reserved to the several states will extend to all the objects which, in the ordinary course of affairs, concern the lives, liberties, and properties of the people, and the internal order, improvement, and prosperity of the state. States hold a special place in our republic, which de Tocqueville explains in Democracy in America as, quote, fulfilling the ordinary duties and responding to the daily and indefinite calls of a community, while the federal government is, quote, circumscribed within certain limits and only exercising an exceptional authority over the general interests of the country. Too often today, the federal power is regular rather than exceptional, and the needs of the environment are the pretext for the reversal of the allocation of power. Environmental, land use, energy, and natural resources all are issues and wonderful examples of the mismatch in the allocation of authority from the founders' design and today. To begin what can only be a brief evaluation in the short time available, let us consider the decision earlier this month by the Obama administration to issue a moratorium on new coal leases on federal lands. A January 15 story in the Washington Post called the new moratorium, which halts new leases until the costly and lengthy completion of a programmatic environmental impact statement, quote, part of a sweeping review of the government's management of vast amounts of lands and resources, including many of those mentioned by Judge Smith earlier in his introduction. That coal leasing moratorium may very well signal the start to even greater new hostilities toward resources development by this and successor administrations, even beyond what we've already seen, with a broader locking down of resources and on the horizon beyond coal. After all, in her statement regarding the memorandum, Interior Secretary Sally Jewell stated that it is abundantly clear that times are different in the energy sector today than they were 30 years ago, and we must undertake a review. That's what we need, and as responsible stewards, we must protect the nation's assets. One concern in the leasing program supposedly leading to the moratorium is that the federal government gets poor returns from its leases. Yet this is a problem by which state managers seem less afflicted, because they are freed of some of the politics and better capable of monitoring and adapting to price changes. BLM's fair market determinations on coal sales are a problem of its own making, and its regulatory morass prevents more dynamic and informed setting of sales prices according to the true value of the asset. The very idea that the federal government can deny access to this coal underscores the role it plays as a landlord over the resources subject to leasing programs. But it is a landlord who is distant from her property and who does not have the full attachment necessary to properly care for and manage it. In fact, the leasing program landlord-tenant relationship serves as a larger metaphor for the federal government's treatment of much of the property, including natural resources, within states. The federal government often acts like an under-incentivized and detached landlord who has little regard for the states that it treats like tenants to which it has few obligations and whose tenancies can be conditioned in numerous ways. The coal leasing moratorium is certainly not the only way that federal policies have led to suboptimal land and energy resource decisions. The list of examples is extensive, but certainly includes duplicative and costly regulation of hydraulic fracturing for oil and gas, impediments to pipelines construction like with Keystone XL, the expanding regulatory reach that you've heard so much about today on the recent WOTUS or Waters of the United States rule, which is being challenged by more than half the states, and excessively long time frames for permitting, even including for siting and operating renewable resources like wind turbines or solar farms and other land-dependent activities. And back to the areas owned and managed by the federal government. The poor management by the federal overseers is evident across a variety of resource concerns. For example, according to a 2015 report studying land management in 4 western states, Montana, Idaho, New Mexico, and Arizona, conducted by research fellows from the Property and Environment Research Center, or PERC, Holly Fretwell and Sean Reagan, the states, quote, earned an average of $14.51 for every dollar spent on state trust land management. The U.S. Forest Service and Bureau of Land Management generate only 73 cents in return for every dollar spent on federal land management. That means that quote, the federal land agencies lose taxpayers nearly $2 billion per year on average. The study reported high costs and low revenues in federal management of timber, for example, due to excessive layers of costly planning required by regulations and bureaucratic obstacles. The reverse was true on both metrics in state management. During 2009 to 2013, the report states that, quote, the states earned an average of $114 per 1,000 board feet sold, while the Forest Service lost $148, and the BLM lost $197. The same was true for grazing. From 2009 to 2013, the Forest Service generated 10 cents on every dollar spent on rangeland management, and BLM generated 14 cents. State trust lands, by contrast, earned an average of $4.89 per dollar spent on rangeland management. Similarly, between those same years, quote, mineral production from federal lands earned taxpayers about $20 for every dollar spent. The return from mineral production on state trust lands was $138 per dollar spent. Even for those energy and environmental areas where we might concede that the federal government has authority, that should not end the matter. Even when one entity can do something, it doesn't mean it always should. Even when one entity, like the federal government, is distant from the property, it cannot assume that it can manage well. They are less familiar with unique issues. They are not experts, and thus they have an information deficit. They are not close to the property. They may also have other masters to please in a way that diminishes concern for the local resources. And they do not have the emotional connection to a place that, as I will discuss in a moment, acts as a powerful, positive, and protective force. In contrast with distant overseers, those closest to property usually manage better. States and localities are more capable of customizing land and resource policies to meet the particular needs and conditions within a state. And states also have greater flexibility and adaptability, more independent decision-making, and respond with greater agility to changes when necessary. So why do we so often end up with the current upside-down allocation of authority? When those who are cautious, concerned, or resistant to greater state control over the land and other natural resources within a state's border express their opposition that higher level of state or private control and a lower level of federal involvement, they often base their worries on the ideas of overexploitation, race to the bottom, plunder of the lands for pure profit, and other like concerns. Oftentimes, that same rhetoric is used to contend that underregulated private property ownership fosters atomistic and exploitative tendencies based on selfishness and profit incentives. In my final minutes, I wish to challenge these assumptions and explain some of the reasons why we should trust states to manage and regulate land and natural resources within their borders. Because of limited time, however, I will not defend here the correlation between wealth maximization and good stewardship of resources, although I believe the link can be established, and some of the material available in one of my articles in your CLE materials addresses that. My current research in property law reveals that the incentive structure in the care, maintenance, and improvement of real property is more textured than typical wealth maximization models display, and that's where I'd like to focus for a moment. Pride, too, plays a role, including contributing a tempering influence against overuse of resources. The pride in property research focuses on examining motivators of investment. Traditional rationale for investment are typically based on ideas of economic motivation. Do we not labor so that we can keep the fruits of the labor and gain ownership in things? Do we not make investments in property so that we can see a positive monetary return and increase its value? I accept these traditional factors as true, but those motivators do not tell a complete story of human action. An alternative, sometimes separate and sometimes concurrent explanation for laboring to improve or maintain real and personal property lies in pride of ownership. Or, as I hypothesize related to the states, pride in an attachment to the property or a place that operates similar to ownership. Why we paint our houses, landscape our lawns, wash our cars, and the like can be traced to pride-based rationale and not simply wealth maximization. Sometimes we invest in our own property simply because of our special and unique attachment to it and affection for it. We invest not so much because we want to increase market value, we invest because we want to increase personal value. And oftentimes there's a personal satisfaction or pride from making things you own last longer and or get better. Pride motivates real property owners to make subjective investments in their property, often leading to the accidental but happy consequence of an objective increase in value. In contrast, for example, renters have far less pride associated with their property interests and are not as likely to maintain and care for it in the same way that those who plan to die in their home might. Most of that analysis so far applies generally to individually owned property, but it seems logically to extend as well to lands and resources, held publicly or privately, to which individuals have developed a geographic and historical sense of connectedness, such as where citizens of a state have an ownership-like interest in a similar way than a homeowner cares for his home. Indeed, higher levels of state management and control may bring ownership-like attributes that are even more salient than when we speak of attributes regarding individual ownership. This is because people may connect to the resources within a state as owners, but also see the resources inextricably linked with the place in which they exist and for which the people have affection. In Federalist 17, Alexander Hamilton opined that, quote, "It is a known fact in human nature that his affections are commonly weak in proportion to the distance or diffusiveness of the object. Upon the same principle that a man is more attached to his family than to his neighborhood than to the community at large, the people of each state would be apt to feel a stronger bias towards their local governments than towards the government of the Union. The power of these connections between people and places that aid in their preservation and are increasingly studied are revealed in fields like geography, sociology, anthropology, and ecology. We lawyers and policymakers would do well to learn from those fields. The pride of place, when tempered with prudence and respect for legal systems and structures within which it must operate, is usually a positive force. If we ask ourselves, when do individuals take the best care of land resources? The answer is when they own it, or at least when they have an ownership-like stake in the property, when they are given some special legal status and officially recognized connection with the property. When ownership-like values are strong and individuals maintain a high degree of control over their property, they are better stewards of it. Freeing states and people from overbearing and unnecessary outside control ignites the flame of pride that is otherwise dimmed or even extinguished when pervasive federal control over their resources becomes the norm. Consider Tocqueville again on the comparative affection for states versus the federal government, including when it comes to natural resources. He explains that, quote, "The Union is a vast body, which presents no definite object to patriotic feeling. But a state, quote, represents a certain number of objects that are familiar to the citizens and dear to them all. It is identified with the soil, with the right of property and the domestic affections, with the recollections of the past, the labors of the present, and the hopes of the future. At least for those things that resemble property like most energy resources do, we should return to treating those with the most proximate geographic claim to those resources as their guardians." Thank you.
Good afternoon. My name is Justin Pideaux. I'm a professor at the University of Denver's Sturm College of Law. But like Rick, I'm going to be speaking a little bit with sort of a second hat, which is that prior to my time in the academy, I was an appellate lawyer at the Department of Justice. And you'll see why that is relevant to my remarks, since I will be, in some sense, defending the United States before you, just as I once did before judges like Judge Smith. First, let me thank Judge Smith for moderating this panel and also thank the Federalist Society for both allowing me to offer some comments this morning and allowing me to escape Denver's winter for a few days. So thank you for that. So as I mentioned, the topic that I'll be discussing is related to the United States, and specifically I'll be discussing settlements that are entered into in the environmental context between plaintiffs and the United States. And perhaps a little bit counterintuitively, I'll be discussing why those settlements or how those settlements may implicate federalism values, at least in practice, if not as a formal matter. At the conclusion of my remarks, I'll be explaining why, at least from my perspective, these settlements, while there has been much hand-wringing about them, aren't actually a problem from either a legal or policy standpoint. So the term environmental settlements may not set off any sort of notes of recognition for you, so let me offer another term that has been sort of featured prominently in the debate over these settlements. You may have heard of the so-called sue and settle debate. There's a lot of interest in Congress right now about this phenomenon where there is a lawsuit brought, typically by an environmental organization, and then a settlement or consent decree is entered into to terminate that litigation. And for one example, the U.S. Chamber of Commerce produced a report a couple of years ago identifying 70 settlements that, in that organization's view, were sue and settle settlements that fell into this category. Interestingly, prior to the Obama administration, there were actually a lot of environmental groups who were similarly raising concerns about settlements that had been entered into between the Bush administration and various private sector entities with the same concern, that there was something suspicious about these settlements, something improper, or perhaps something illegal. The arguments against these settlements are multi-pronged. let me identify sort of three primary arguments, although there are others. First, the argument goes that these settlements allow interest groups to dictate the agendas of federal regulatory agencies, right? So it's the plaintiffs get to decide what the agencies will prioritize rather than the agencies themselves. Second, the argument goes that in some circumstances, these settlements or consent decrees may enable agencies to make regulatory decisions while circumventing traditional safeguards created by administrative law. And third, and relatedly to point two, there's a concern that settlements and consent decrees avoid public participation. Now just to suggest to you how hot this topic is, at least in Washington, D.C., I testified before a Senate subcommittee about it 6 months ago, and just a few weeks ago, the House of Representatives passed a law, the Sunshine for Regulatory Decrees and Settlement Acts, that would impose a variety of procedural requirements on federal agencies in the environmental context before they enter into any settlement or consent decree. So none of that sounded like it has much to do with federalism. So why am I on this panel at all? Well, I think one of the primary, maybe that's the end of the talk. So I think one of the primary advocates for this concern about sue and settle have been states, and I think states argue that in terms of public participation, they are one of the interested parties which are kept out of the regulatory process when federal agencies enter into these settlements or these consent decrees. Now, to be clear, I'm not familiar with any arguments that as a formal matter, federal agencies have been engaging in settlement practices that limit the legal authority of states. It's really more of a non-formal process-based argument that in the ordinary course of doing business, federal agencies talk to states before they enter into regulations, before they enact regulations. And from my experience in the federal government, I think that's a fair characterization of how the regulatory process goes. Now, obviously, the federal government and the federal agencies don't always reach decisions that all the states like. Indeed, I'm not sure that they could ever reach a decision that all the states like. But at least in most circumstances, federal agencies do solicit the views of states, and I think take those views seriously. So what kind of cases are we talking about? Well, the cases that I'd like to focus on in my comments are sort of invoking again perhaps the least popular environmental law, the Endangered Species Act. There have been a fair number of settlements and consent decrees in the context of ESA lawsuits, and specifically these lawsuits arise out of ESA deadline provisions. So the Endangered Species Act says in certain circumstances the federal agency has a set time period to reach a decision. Right, and often the ways what these decisions are is that a citizen group petitions for the listing or protection of a species, and the Endangered Species Act sets very short deadlines for the Fish and Wildlife Service or the National Marine Fisheries Service to respond to those petitions, either approving them or deciding not to approve them. So the question, I suppose, is, from a federalism perspective, are these settlements of deadline lawsuits under the Endangered Species Act or other statutes like the Clean Air Act, truly preventing states from participating in federal regulatory processes? And I think it's, as I said, fair to say that states have much to offer in these processes under the Endangered Species Act. They not only have ecological and technical information to offer, but they also have information to offer about the wildlife conservation efforts by the state itself, which may preclude the need for a federal intervention. Now, my answer to this question, is there a federalism problem, is no. I don't think there is a federalism problem here. And the reason for that is the types of commitments that federal agencies are engaging in through these settlements. These settlements, by and large, involve some of the following circumstances. A, the federal agencies have no good legal defense. Federal agencies are going to lose these lawsuits. They will lose these lawsuits every time. And when they lose these lawsuits, courts will impose deadlines that are created by the judge as to when the federal government needs to comply with its statutory mandates. So that's sort of point one. Point two is that agencies make resource decisions and priority decisions all the time without engaging the public or the states. Those kinds of decisions are not the types of decisions that require public participation under the Administrative Procedure Act. So in other words, the settlements commit the agencies to do things that they have the power to commit themselves to do without talking to anyone. And so as a result, I don't think there's any circumvention of existing administrative law or public participation requirements. And the reason is this: the way that the terms of these settlements do not bind the federal agencies to any specific outcome. The federal agency, the Fish and Wildlife Service, doesn't enter a settlement that says, we will list the greater sage grouse under the Endangered Species Act. Rather, the settlement says, we will make a decision as to whether or not to list the species under the Endangered Species Act. Now, I think I can foresee two objections to my line of analysis, that there really is no federalism implications, or at least that we should be relatively unconcerned about these settlements. The first, I think, takes issue with the statement I just made. Some have suggested that indeed, through these settlements, which are only committing to making decisions, agencies are tacitly agreeing to make particular decisions. Right? That in a settlement where the agency says, fine, we'll rule on your petition seeking protection for a species, that in that settlement negotiation, the agency, maybe through a wink and a nod, is saying, and we will in the end list that species as endangered or threatened. Now, I think that the evidence simply doesn't bear out this criticism. It is a criticism that's been made in a number of circumstances. The Fish and Wildlife Service, after satisfying its obligations under settlements it's reached, has decided not to list species, and the Government Accountability Office conducted a study specifically looking at this question and found no connection between settlements and the types of ultimate consequences, or sort of the ultimate decision. Also, I think it's fair to say that courts are very willing to intervene when they think that federal agencies are making substantive commitments in these settlements or consent decrees. In the Ninth Circuit in recent years, there was a case called Conservation Northwest versus Sherman. That was exactly the set of circumstances there. There was a consent decree that was entered into. The consent decree clearly made some substantive modifications to a forest plan, and the Ninth Circuit ruled that that consent decree was improper because the agency needed to go through notice and comment rulemaking in order to make such a decision. So the second objection I can envision is related to one of my earlier points, that what's really happening here is that interest groups are being enabled to set the priorities for federal agencies. Now, to me, there's something of a disconnect in this line of reasoning, and for the following reason. It's Congress who has set these priorities for federal agencies. Congress has developed a statutory scheme through which citizen groups can petition agencies for rules, and under which the agencies have statutorily mandated timelines by which they need to ask. So let me give you a hypothetical out of another less controversial context. Imagine a state law that required a zoning board to either decide to approve or disapprove a building permit within 6 months of that building permit being issued. It would seem odd to me to say that a developer who sues the board after 6 months has elapsed, is somehow usurping the board's discretion. Rather, the board has violated a clear statutory duty, and the developer is simply seeking to hold the board's feet to the fire. And I think the same line of analysis applies here. Now, to my mind, the real objection to environmental settlements have nothing to do with the settlements themselves, but indeed are objections to the underlying substantive environmental policies that are embodied in federal environmental law. People don't want species to be listed. They don't want them to be listed soon. And so settlements become a way of objecting to such listings while appearing to make a process argument. I think there is fertile ground for debate about the terms of the Endangered Species Act and other federal environmental statutes. I tend to disagree in many circumstances with those that oppose environmental settlements, but as I said, I think we can have that debate. However, limiting settlement authority strikes me as an unmitigatedly bad idea. Now, why do I say that? Well, first, because the federal government is incredibly unlikely to prevail in these cases, preventing settlement will simply increase costs. It will increase costs to the courts. It will increase costs to my former colleagues at the Department of Justice who will be forced to litigate cases that could be settled, and it will increase costs to taxpayers because in most of these contexts, attorney's fees are available, and if you force an environmental group to litigate through judgment, those fees are going to be higher, and that is going to come from the federal treasury. Finally, I think settlements in this context actually enhance rather than detract from agency discretion. The circumstance that we have before us is one in which, as I said, the federal agency will lose. So the federal agency can either negotiate a settlement with the plaintiff, adopting deadlines that the agency thinks are realistic for it, or the federal agency can wait for an unelected judge who will do his or her best to come up with something that seems equitable but will impose a deadline by judicial fiat. In such circumstances, I would suggest to you that settlements are the better course. Thank you very much.
We don't have a lot of time, but you've been very, very patient, so I'm going to give you some brief medical advice before we go to the next part of the program. Some of you, I can tell, have no difficulty sleeping. Others may. And if you do, it's been proven that if you take a copy of the EPA's new Clean Power Plan and you put it by your bed and you start reading, you will fall asleep. And unlike Ambien, when you lose your memory, you won't care. So we have just a little time left. We want to save about 5 minutes for questions. So do any of my colleagues have any questions they'd like to propound to other members of the panel? And we'll stop at 3:25.
I'm programmed to answer questions from judges, so if,
okay,
that would be my preference.
Let me do that. I don't know how many members of the audience are familiar with this, but there is a doctrine called the public trust doctrine. It's an ancient doctrine from the time of Justinian, believe it or not, in which it was held that the so-called res commune, which are common assets like water, like air, and so on, were held exclusively for the benefit of the public. In California, that is written into the Constitution of California and could potentially lead to where the state could take otherwise private property and use it for the benefit of the common good. That has historically been considered a state matter, and the D.C. Circuit recently decided a non-published opinion to that effect. But I want to ask maybe Rick or Tony, I think you're involved in this a bit. Because we have things like water, like air pollution and so on that go across state lines, is there a possibility that the public trust doctrine could be applied as a matter of federal law, and what impact, if any, would that have on federalism?
Well, I'll go first. I think the short answer to your question, Judge, is no, and that's because although the most important public trust decision in the history of the United States is in all likelihood a U.S. Supreme Court decision, Illinois Central from 1892, which invalidated a wholesale grant of the Chicago waterfront by the Illinois legislature to a railroad company as violative of newly articulated then public trust principles. It was just a few years ago that the U.S. Supreme Court, in an opinion, I think a unanimous opinion authored by Justice Kennedy, held very definitively that the public trust doctrine is purely an issue of state law. And so whereas the public trust doctrine has been embraced in some state court systems quite eagerly and fully, and I think of Hawaii by court decision, Vermont by legislation, California initially by court decision, and recently in the water rights decision, 2009 legislation finding that the public trust doctrine is a cornerstone of California water rights principles. Similarly, in some states, it has not prospered and has been rejected. In Colorado, by their appellate court system, and in Idaho, where an Idaho court had initially embraced and adopted the public trust principles in water rights setting, the legislature immediately responded by essentially overruling that court decision. So I would submit, in answer to your question, that it is a state law doctrine and one that has evolved or not in respectful of the basic principles of federalism, that some states are embracing it, some rejecting it, and may 1,000 flowers bloom or not.
What I would add, there's a couple of recent decisions that I mentioned earlier out of the Ninth Circuit dealing with Federal Reserve water rights. The federal courts recognize a federal navigational servitude that arises, or is recognized, I suppose, by the Commerce Clause, But the Ninth Circuit has specifically held that the navigation servitude is not a basis for finding Federal Reserve water rights. And this question actually came up in oral argument at the Supreme Court a couple weeks ago in a case called Sturgeon versus Frost, which deals with whether the Park Service can regulate use of water on non-park property transiting the park. And the idea there is you've got the outer boundary of a park. So if one of the tables there is the boundary of the park, but within it there are all kinds of inholdings and other non-federal properties that the park doesn't own. And the question in Sturgeon versus Frost is, to what extent can the Park Service regulate use of water on property it does not own that are within the outer boundaries of the park? The members of the court that addressed sort of the theoretical underpinning of the Federal Reserve water right were very clear in agreeing, at least in this limited respect, with the Ninth Circuit's view that the navigation servitude has nothing to do with any of that. So I would agree in general that I do not see a significant federal role for imposition of the public trust doctrine. However, there's so that's sort of at the legal level. I think, from my own observations, there's sort of a sub rosa application of the public trust doctrine as expressed in states by federal agencies. So, for example, in California, the State Wildlife Agency, the State Water Regulatory Agency, and the federal wildlife agencies, NOAA Fisheries and Fish and Wildlife Service, cooperate very closely on protection of wildlife and aquatic species in particular. And in my experience, you will see federal agencies making decisions purportedly to protect the state's public trust interest in various water resources. So as a practical matter, that may actually require a resolution, whether a federal agency actually has any power to do that. Remembering always that you have to locate the ability to enforce a public trust doctrine in some grant of authority in the Constitution.
If I can just very quickly.
Yeah, I just wanted to augment my earlier comments. While I think it is a state law doctrine, that's not to say that federal courts are not occasionally going to be drawn into the battle. There was a recent federal district court decision in Nevada attempting to articulate, interpret, and apply Nevada state public trust law in a way that, in my mind, raises some interesting federalism questions. That issue is in the Ninth Circuit, so that will have to be resolved there.
Well, we have just about 5 minutes left. We've been very patient. We realize this is a technical subject, but this is a very, very important part of federalism because the way the environmental law is applied and how much of a role your state government, your local government versus the federal government has huge implications for your property ownership, your quality of life, and the like. So we appreciate your taking this all in today. I really regret we don't have more time to ask more questions, except we're going to ask whether there are any questions from the audience. We have just about 5 minutes. Does anyone have a question? If not, we'll have panel members. I don't see any. Oh, there's one right there.
I want to ask about your theory on public nuisance litigation. It seems like that might have the undue effect of drawing federal courts. Thank you. Of drawing federal courts and federal judges into some very particular regulation of land. I mean, your remarks were on fire abatement, and it seems like, I mean, most of us in the room think, oh, that, it's kind of simple. You've got dead standing wood there. A judge could order them to go cut it down. Coming here from Washington State, the public nuisance might be somebody suing and asking a federal district court judge to take over the management of the Hanford Reservation and disposal of radioactive waste. It seems like there's sort of a scale of possible public nuisances, and I'm not sure there's suitable limits on the doctrine once you get the courts involved. I wonder what your thoughts are on that.
No, thanks for the question. So the Michigan versus Corps of Engineers decision does address that, and the case itself deals with what is probably an unintended consequence of a ban on an aquatic herbicide, because it starts with some rice farmers in Louisiana introducing two non-native carp species into their rice fields to control weeds. Some years further down the road, the non-native carp are threatening full-scale invasion of the Great Lakes, and the case is about whether or not the Corps of Engineers can be compelled to close the infrastructure intertie between the Mississippi River Basin and the Great Lakes, which runs through either the city or the suburbs of Chicago. And what the Seventh Circuit said in that case is that one of the reasons it would not grant the relief requested was that what they were requesting was a very specific solution to the problem, and that while a federal court can order a nuisance abated, the format of that needs to look more like your order to abate this nuisance, you need to supply a plan that respects the agency's discretion in how to do it for court approval. And I think that's the answer to that question. You then wind up in I think, a more complicated problem. Depending on how much discretion the agency has in how to abate the nuisance, what other federal laws is it subject to in proposing a plan? You know, is it subject to NEPA? Is it subject to the ESA and these other things? So I don't think it's an easy approach. However, it is possibly something that can put more leverage in the hands of states and local communities to force action, which right now the inertia is all in the direction of leaving the forest to accumulate more and more fuel or burn to the ground. So, you know, it's a possibility. It is not, to my knowledge. The other question with that theory is whether, and the paper addresses this, any federal statute displaces the common law public nuisance theory. For example, the way the Clean Air Act displaces air pollution claims under that theory, and which, you know, might, for example, apply in the case of dealing with nuclear fuel. So,
probably have time for one other very short question. Anybody else have a question? Looks like there's one there, one in the back as well. There's one over there, there's one back there. Pick one. Anyone.
Thank you very much for this wonderful panel. The question goes for any of the panelists. Do any of you have opinions on a more wholesale transfer of public lands from the federal government that would reduce the disparity between the amount of land owned by the federal government in the western states compared to the rest of the country?
Anyone have a view they want to respond? Go ahead.
As many of you may know, there's been a variety of state statutes, Transfer of Public Land Acts in a variety of states, starting in Utah, to demand upon the federal government that they return or dispose of to the states certain land holdings that the federal government holds. A variety of different theories are being posited from a compact-based theory, which says that the original enabling acts provide some obligations on the behalf of the federal government, everything from that to equal footing doctrine and a few other legal theories. So I think it's an interesting approach. It may have merit in the differing merit based on the type of claim that's being made. But the one thing it does do is it demonstrates the desire by the states to take over the management role. And whether or not you have an actual transfer of the lands themselves, even short of that, one thing to consider as a policy option is that even if the fee stays basically in the hands of the federal government, that the states could take on a management role and have some of the efficiencies that I discussed in my talk take over from there. So I think it's a combination of how much should be transferred in actual ownership and how much should be a management issue.
Thank you. I regret we don't have more time to hear from our panelists. We thank you all for being a very respectful audience. We realize it's a technical subject, and don't forget what I said about the regulations and any sleeping problems that you may have. So thank you very much.